this is the third week of Knowledge November and my second video, aren't you lucky? Wanted to focus on two specific issues in this short video when we're talking about reasonable adjustments, the duty to make reasonable adjustments. The first issue relates to adjusting trigger points. So normal sickness absence policy might have something in it which says if you have a certain frequency of absence or you hit a certain frequency or volume of absences, then you're going to perhaps suffer from some kind of disciplinary consequence. Or you could have policies that work the opposite way. So if you haven't had any sickness absence, then you get more holiday. Or if you haven't had any sickness absence, then you're going to get a bonus. The disabled person is going to say, that's not fair on me because I am more likely than anyone else to have time off in connection with my medical condition. That means you should be discounting in some way their absence when you're measuring either your trigger points or whether somebody successfully achieved their milestone to earn a bonus or holiday or something. It can be a reasonable adjustment for you to then tweak your trigger points. So you might extend where you would normally be taking action to a further point in the future and extend more generosity, if you like, to the employee. Now, you're going to say, what's the magic number, Anna? And I can't give you one because the judges are very loath to sort of dictate to employers. It's all going to depend on the circumstances of the case. As a broad rule of thumb, you're probably not going to get into trouble if you double whatever your normal sickness triggers are. And it may be that you need to get some specialist advice around the proposition that the employee is putting to you around absence levels as well. So you either need to get really detailed advice about the specific absences that somebody's suffering from, or sort of generic advice about somebody with this condition. So if I am employing a diabetic, what can I normally expect to see? And that might inform you what adjustment you then make. But certainly that's one area where you're likely to be required to make reasonable adjustments. I think about it in terms of the narrative I want to be able to tell a judge. I want to be able to say, yes, this is what our normal policy says. We went far above and beyond that, and we still had a problem, and then that justified us doing something about it. The second area that I want to touch on is sick pay, because that does come up all the time. The general proposition is if somebody's sick, you are not required to make them up to full pay. That's the general proposition. And the reason why that is the general proposition, it was discussed in a case called O'Hanlon and HMRC back in 2007, is that the whole purpose of the disability legislation is not to require you to sort of act as a charity towards people. The whole point of the legislation is to focus on people, getting people into work, rather than them staying off on the sick. So general proposition, not required to enhance pay if somebody has a disability and that's the cause of their absence. There are circumstances, however, where you might need to go further than that. So classic example is the Meekler case, which predated O'Hanlon, which the reason why the employee was off is because the employer hadn't made the reasonable adjustments that they were supposed to be making. In that case, the employer is causing the absence. So surprise, surprise, the judges found that her pay should have been made up in those situations. You will undoubtedly have employees who will perhaps move into a lower role as a result of their disability or as a result of trying to get them back to work following absence. And that lower role may well have a different price tag to the role in which they've been employed up until now. Generally speaking, the law is going to support you paying them whatever the relevant price tag is for that particular role. Unless, there's again some fault on the part of the employer that they can't do their role because we haven't made the reasonable adjustment that they need to be able to do it. So the courts are very loath to require an employer to pay an employee, but there have been cases where there have been sort of specific factors, I would say, where the judges have found that it's reasonable to keep somebody in their paid position even though they're doing something slightly different. So there was a case of an engineer whose job required him to travel all around London on the tube, and he had issues which meant that he couldn't do that anymore. And they found in that circumstance, although he was going to stay being an engineer, he didn't drop down onto the pay of other colleagues who didn't have the travel element involved in the role. So it is worth thinking about pay. You're always going to look good if you have extended some discretionary sick pay to people. If you can say to a judge, we've gone above and beyond what we normally do here, this is what we've done, we've been very generous, we've gone above and beyond, but we hit a certain point where we couldn't do any more, then they're going to accept that. They're going to be impressed that you've made the adjustment to your normal policy and given that little bit more. If you've got any questions, please do let me know. It's adenton@refreshinglawltd.co.uk. Thank you very much.